Assalamualaikum and hi everyone, I'm SYAFIKHA. In this presentation, our group will talk about a case that we have chosen, which is HEDLEY versus HEDLEY and Partner 1963. So, this is an imposter that we have made based on the case we have chosen. This case is about negligent misrepresentation between HEDLEY versus HEDLEY. HEDLEY were advertising agent placing contract on behalf of a client on credit term. HEDLEY will be personally liable should the client default. To protect themselves, HEDLEY asked their bankers to obtain a credit reference from HEDLEY and Partner, which is the client bankers. The reference given both orally and then in writing was given gratis and was variable, but also contained an inclusion clause to the effect that the information were given without responsibility on the part of the bank or its official. HEDLEY relied upon this reference and subsequently suffered financial loss when the client went into liquidation.
Hi, my name is RABIATUL Binti NURUL. Okay, I will share about the chronology of this case. In this case, HEDLEY as plaintiff while HEDLEY and Partner are defendants. HEDLEY were advertising agency were approached by a company called Easy Power Limited who initially want to submit a large order to HEDLEY and want to spend 80,000 to 90,000 possibly for advertising time on television and newspaper in credit terms. Under this contract, the plaintiff became personally liable for the sub-view. On 4 November 1958, HEDLEY think that this is a good amount, so HEDLEY asked their banker, the National Prohibition Ban, to communicate Easy Power Ban, HEDLEY and Partner for a referred and Easy Power financial position and credit worthiness to enter into a contract. Later on, 7 November 1958, bank wrote to the defendant and their partners who were easy for banker to find out whether the company was trustworthy in the way of the business. Then, on 11 of November 1958, HEDLEY and Partners will reply the reference even gratis and were favorable but also contained an exclusion clause to the effect that the information was given. HEDLEY and Partners say that the Easy Power was a subsidiary, a large corporation which was in liquidation, but Easy Power created successfully. HEDLEY and Partner reply stated that confidential for your private use and without the responsibility on the part of this bank. Easy Power considered good for its ordinary business engagement. After that, HEDLEY relied on this statement and they filled the order. HEDLEY started purchasing advisory stakes on behalf of Easy Power. After a few months, Easy Power subsequently into a liquidation and HEDLEY money approximately was £70,000, which is a huge amount considering in the late 1950s. HEDLEY sued HEDLEY and Partners in negligence for the money that they have lost as a result of their reliance on the reference and claiming that HEDLEY and Partners ban was the cause of applause. HEDLEY and Partners rely on precedent that there will no duty of care for mere statements. HEDLEY and Partners may also argue that even if there was a duty, it is without responsibility that saves them from any liability.
Assalamualaikum warahmatullahi wabarakatuh. I am Nurzahidah Nafisah Binti Ibrihim. In this presentation, I will continue on court held on the 28th of May 1963 at the House of Lords. The court held that the HEDLEY and Partner was not liable to HEDLEY because of the express disclaimer of responsibility in its letter dated 11 November 1958 that stated in the letter without responsibility on the part of the bank, which is the disclaimer. The court found the relationship between the parties was sufficiently proximate as to create a duty of care. The relationship was that the plaintiff trusted the defendant with the information and therefore the defendant ought to have been honest. However, on the fact the disclaimer was sufficient to discharge any duty created by HEDLEY's action, there were no order for damages because a man cannot be said voluntarily to be undertaking a responsibility if at the very moment when he is said to be accepting it, he declares that in fact he is not. That's all from the court held. Thank you.
Finally, how is the case related to the theory of banking operation? Negligent misstatement is not strictly part of the law of mispresentation, but is a thought based upon the 1964 arbiter dicta in HEDLEY versus HEDLEY, where the House of Lords found that a negligently made statement, if relied upon, could be actionable provided a special relationship isn't things between the party. The case is related to the bank opinion. It was held that a bank is under a duty to assess a scam when giving a reference on his customer to a third party if he know to have known that a third party will reply on such information.